synopsis, and the only thing you're really going to get off of them is the votes. That's the only thing that's really required. Who votes for what or for whom within the minutes. The rest of it is, you know, how much more they choose to put in there. So, you know, if you've got somebody who says, watch this is going to become part of the public record, and they get this grand soliloquy, you know, they may not even put it in at all, and that's certainly okay. The only thing that's required in those minutes is the record of who votes for what or for whom.
How do they have to post those minutes? Because I know my fire commission, like, they used to post them online, and now, like, 4 or 5 months later, they post their meeting minutes.
Back in 2008, the legislature passed a law that said, is that me? Oh yeah, okay. Said everything had to be posted online. But a lot of the smaller towns bitched and moaned, complained. So they peeled that back a little bit. The only actual requirement for online posting is special meeting notices. That's the only thing. So the minutes don't have to be online anywhere. The requirement is that they have to be available within 7 days. And where they're available, it was really not specified either. A lot of people turn them into the town clerk, but if they have that copy within 7 days at their office, that's all they need to do. Anything else on meetings? Anything else you want to chat about? Or
I just tend to find, and I don't, this is more of a comment than asking for a solution, because I don't know that there is one, but it just seems to me that in the 16 years I've been in Connecticut, there are a lot more boards and commissions that will do stuff that kind of, to me, in a gray area, and say, just so to test it, because they know that timeliness is, you know, a key to reporting the news, and if it's not something huge, it's going to keep resurfacing and resurfacing. They do lots of shady stuff, I think, that, and want you to go ahead and test it, because they know by the time that there's actually a decision rendered, it'll be...
One of the frustrations in being a reporter and knowing this law is just what you said. This law does not necessarily help you meet deadlines. Sometimes the threat of being found out, acting improperly, does carry a lot of weight, but not always. In other words, they violate a meetings provision Monday night, you file a complaint, it's March, you know, maybe sometime in August you get a resolution. It doesn't help you with that story, but they now have been told that the way they planned that executive session and the way they did that is wrong, and they are on notice. And your story says, you know, Wallingford P&Z violates FOI Act, violates state law. But as far as getting the story that day, as far as getting it, if they were clearly wrong in the executive session, it doesn't help, and I understand that frustration.
Well, I mean, I'm not even talking about for the next day. I mean, if a decision comes months down the road, it's sort of like inside baseball. I mean, we care about it, and maybe it sets a tone with them, or maybe it doesn't.
It should for the next time. They should be well aware that, you know, they're not doing it properly. And yeah, I understand what you're saying. I do, because you know, having been on both sides of the fence, I get it. It's just there's just no provision. There are some who suggest that our ability to penalize should be stronger, and maybe someday, if you know, some of the things that were revealed in your last survey continue, maybe it will be. But
I'm not hopeful for that. Not with what the stuff
It's
that
quite the opposite.
that was the stuff about Newtown that's going down.
Yeah.
That was a travesty.
yeah, well, we didn't like it either. But believe it or not, we were actually able to modify some of the, or sort of soften some of the proposals. We fought to soften them.
Now, what happens if the legislature doesn't pass the recommendations of the task force? Do we go back to square one, or is it based on what was passed in the last legislative
It
session?
would be the last law, except for those provisions that elapsed in May. There were a couple of them that elapsed in May, I think.
So it's what was passed at the end of the last legislative session.
Right. Our firm hope is that the task force recommendations go down. I will be candid. The person who led that task force, who was allegedly on the media side, has no idea what he's talking about.
Don DeCesar, yeah.
No idea. He doesn't represent anything closely resembling open government. I don't care who hears me say that. That was a travesty.
I'm involved with Connecticut Society of Professional Journalists.
Yeah.
I used to be on the board, and the fact that the current president of the Connecticut SPJ voted for it because it was a compromise is a joke. I'd rather go down in flames and be one of the few people to vote for it. But that's...
I know Jody and I respect her integrity, but I would respectfully suggest that she went down the wrong path on that one. Yeah. Now, any other questions about me? First of all, what kind of time do we have? I mean, I consider all that.
I have all day. I don't know.
You
what
guys have
rest-
deadlines and stuff like that. I don't want to.
I have one other question. It's not related to government,
Yeah.
but a publicly traded company, when they hold their annual meetings, and I will grant you, annual meetings, not a lot of really hot news comes out of annual
They usually
meetings.
get a good dinner out of it. Yeah.
Well, anyway. If it's a publicly traded company, can they ban reporters from annual meetings?
Yeah, well, under FOI. There may be another statute that allows you in, but FOI doesn't have anything to do with that.
Okay.
Yeah.
Even though it's a publicly
Yeah.
traded company? Okay. I
I
mean, I haven't run into that a lot, but.
Yeah.
I have a meeting question from Twitter. What are the FOI rules regarding meeting teleconference calls?
Okay. For a teleconference call to be a proper meeting, it would still have to be noticed. Somebody would have to be in the room. If you're following me, somebody would have to, call the meeting to order. And if everybody else was on the phone, that technically would be okay. But they can't have the teleconferencing call, the chairman sitting in his office, his professional office, and putting everybody on the phone, because that's clearly an unnoticed meeting.
And the public could be invited to the one person who's...
That's right,
Okay.
that's correct. We ran into that a bunch this winter with the horrible snow and meetings. Well, we've got a meeting that we have to have. It was in East Haddam, meeting we absolutely have to have tonight. It's scheduled, it's noticed, but we're worried about the snow. So they sent one person who lived close to the town hall down there, put the rest of them up on speakerphone. Obviously, no public came, but the meeting was properly noticed. They convened it, and they went forward and did their business. So that would be okay. Public records. The bottom line, you've all probably looked at the definition 1,000 times. The bottom line with public records is that every record held by every public agency in the state of Connecticut is defined as a public record. Everything. And in theory, anybody can walk in and ask to take a look at it, or anybody can ask to get a copy of it. If it were that simple, that would be the end of the story. On top of those base definitions, though, there are piled what I call the 3 E's. There are exceptions, there are exemptions, and there are exclusions to disclosure. So, you're saying, well, why tell us all this fancy stuff about everything being public and definitions, which I won't read for you because I know you know them. Because all too often, public agencies get really possessive. They got, they're my records, or they're town hall records, or their police records, you can't have them, or you look like a good guy, you can have them, but I know you're a reporter, so you can't have them because I know you're going to do it, and you're not trustworthy, and you can't have them. Or you've made hundreds of requests in the last 6 months, and we're tired of you, go away. What my strongest recommendation for public agencies, including police departments, is, look, someone comes in and wants to see a record, it doesn't matter who it is, it doesn't matter, first of all, you can't ask them what they want it for. If it's a non-exempt public record, you let them look at it, or you make a copy for them at 50 cents a page. It's pretty basic stuff. You do have a right to look at those records and see if there's an exemption in there that applies. If it's a record that you need to have reviewed by an attorney or by a superior or something like that, that's all fair game. But always try to work with the requester rather than sort of throw up a roadblock that says, you can't have it. I used to make up a little story to share with people about what not to do when they got a request for records. But a few years ago, the good city of Hartford gave me a real life example of what not to do. I'll share it with you. The requester was, we'll call him a quasi-journalist. He doesn't do it professionally, but he's got a blog and he's got a public access TV thing, and he's on it, writes op-ed pieces and stuff. And he'd been making a lot of requests during this time period, and I think they'd had it up to here with him. And by the way, that does happen. he asked the city for two things. He asked them for billing records submitted to the city by a particular law firm that had been doing some work for Hartford, and then a record of payments from the city to that law firm. So the Corporation Counsel, the attorney for the city of Hartford, responds, I have your FOI request and will coordinate the response. Such documentation as is allowed or required by law will be provided. Now folks, if you make a written request for records, that's the kind of response that you should probably expect, unless it's a record they're just going to hand to you right away because it's not exempt. And that's okay. The law says that an agency must respond within 4 business days. But respond means something just like that. It doesn't necessarily mean to produce the records. We've got it, we're looking into it. I would always recommend to an agency, and I always do, that they put some sort of a time frame on it, give you some sort of an idea how long it's going to take. But it's not required, but that would make sense. Okay, so far so good. So why is this a good story? Because in the process of responding to this individual, whom they clearly had had up to here and don't like, the Corporation Counsel in the city of Hartford accidentally copied the individual on an email he had written to a colleague about how much he didn't like him. Everything is a public record. Now this is one that may never have seen the light of day if he hadn't hit the wrong button. But the bottom line is he sends this out and it's now in the hands of the requester. I'll clean it up, but you'll get the idea. Carl, so who lit a fire under this? Starts with an A. If he's involved in litigation, ongoing and or other projects that he hasn't asked about, can I shut him down? I told you this guy's a journalist, so he puts it on his blog that he's been called an a-hole. He puts it on, he's got, it's WFSB and it's in the Current, it's on the public access TV, and Hartford looks really, really dumb. So the Corporation Counsel realizes that he may have made a tiny error and he tries to, back up a bit, but he can't do it. He dislikes this guy so much. This is in his letter of apology. Apparently you have little else to do other than to pester me in this office and other city departments. Recall that I do not work for you. The purpose of the FOIA statute is not to provide you a playground. I always tell the agencies, even if you think that, don't write it. Because you've now got 2 public records that say, I don't like you, I don't like your law. What's the point of that? But as reporters, more than almost anyone else, you probably have come to know that kind of reaction. What good does that do the agency? I always tell the agencies, look, they're public records. They're not your records. Yeah, you can review them if you want and see if anything's exempt. But that sort of antagonistic attitude doesn't help anybody. It doesn't work. So the PS here is that they didn't give him the records. He files a complaint, and the FOI Commission says none of those records are exempt. Give them out. Hartford loses at FOI Commission again. Sometimes you may have to push them that way, but it's not what the law is about. I always say, go ahead.
Okay, I'm your point.
If somebody wants to see a record, come in and let them look at it. And if you need to review it, if you need to see to make sure there's nothing in there that shouldn't be released, then tell them, come in tomorrow and look at it. It should not be an adversarial situation. And from your perspective, when you're asking for stuff, don't be afraid to work with an agency. Don't be afraid to say, look, I'll be happy to work with you on that, but you need to understand that we have an open records law here. And I'll take your word for it if you say X and Y are exempt, but Z is clearly not, and I have a right to it.
Once again, Cromwell, they had a gadfly, and he would ask for piles of documents.
Right.
Which they would print out.
Mm-hmm.
They would not come and pick them up. And finally they said, if you want them, you have to pay us in advance.
Right.
Because we're not going to go to the trouble of printing all this and then you never pick
Right.
them up.
That is their right. If the cost of copying is going to exceed $10, you can collect your money up front and not make a single copy.
300?
Yeah,
Yeah.
yeah. So you absolutely don't, they were okay with that, yeah. An agency doesn't have to create a record that doesn't exist. You may go into a police department and think that there's a report that's available, but if they tell you that they never wrote one or they don't have one, you may not believe them, you can challenge them on that, but if they don't have it, the FOI Commission doesn't have the authority to require them to create a record that doesn't exist. And along with that, an agency is not required to do research. They're not required to try to figure out what it is you're asking for. So if you're forming a request for records, be as specific and as clear as possible. And try to narrow it as much as you can. Now, there are times when you're going to have to sort of throw it against the wall and see what sticks. But if you can make it as clear as possible, that will help you get the information you need a lot more quickly, cost you less money, and make things better down the road.
Is there anything that's considered like a reasonable time limit after that for them
Excellent
to
question.
fill the request?
Excellent question. The law says they have to respond within 4 business days. But when it comes to how long they actually have to produce the records, you ready? Drum roll, please. The law says that they have to produce the records promptly. Anybody want to take a shot at that one, wordsmiths?
Without undue delay.
You've heard that before. It went to court. Nobody knew what it meant, and the court said without undue delay. Now, I'm a deadline guy. I told you my background. So you want an hour, you want a day, you want a month, you want something. The bottom line is it's promptly, so it's subject to interpretation. From where you're coming from, when they tell you it's going to take 6 months, you got to kind of figure out whether that's legitimate or not. Again, one of those areas where you've got to interpret the law. They're interpreting to say, oh, it's just her. We don't care about them. 8 months. And then you say, wait a minute. This is a law. 8 months is way too long. How about a month? If it's a big request. So you have to be prepared to say, okay, they're telling me 60 days, I think 45, let's see if I can get them to commit to, you have to have those conversations with them. But you know what, a response within 4 days, if the record's sitting right there, 4 days might not be prompt. If you go into someplace and you ask for an agenda or a press release that they've given out already, prompt is 30 seconds. So, you really have to know what you're asking for and how long you think it should take them to produce it. Many people get hung up on this. The FOI Commission only has jurisdiction 30 days out from an alleged violation. So you submit a letter to Cromwell and ask for records, and they tell you it's going to take 45 days. And after 31 days, you ask where it is, they say, you can't file a complaint. No, nothing stops you from remaking the request. You don't only get one shot at it. So if it's a situation where they say it's going to take 45 days, and then you reach day 45 and they go, sorry, we're not going to give it to you, remake the request and a new 30-day clock starts. You are never out of time when it comes to filing a complaint about lack of access to records.
So if you file a complaint, do you then include that this is the second time we've asked for this?
Absolutely.
And the first
That's
time
far
we
more
saw-
evidence. That's far more evidence for you than before. So long, sure. That's far more evidence than much more evidence for you to make your case.
I have another Twitter question
Yes.
from the Valley Independent. We constantly we can't give you that document until the mayor or the board of aldermen or somebody else has seen it and approve it, and we don't want to step on any toes. Can they reject us on those grounds?
Okay. If the document is a draft document, there is an exemption for drafts, and it's not complete yet, it's not finished, the answer might be yes. But if it's not a draft if they've shared it with 1,000 people. But if it's something that they just need somebody to rubber stamp, the answer is no. The document's complete, it's finished, it should be released. The politics, the heck with the politics. What makes compliance and understanding the records provisions hard are those 3 E's that I talked about. It's important that as you ask for different records, you have some knowledge of what they are. Are you asking for a record that you can't possibly get? You should look at them, and if you're unaware, by the way, always feel free to call us. No question is stupid. Can I get this? Can I get that? We can walk through it. What we tell you is not binding advice. It's just my thought, usually you'll get me, is my thought on what should or shouldn't happen based on the law. The exceptions are harder in that they are not in the FOI Act. The law says, except as otherwise provided by any federal law or state statute. That means if there's a federal law or state statute on the books that says they can't release a record, they can't release it. It would override FOI, but they're not in our law. So you'd have to know, like for instance, if you're asking for a record from DCF, there are exceptions to disclosure from DCF that say you can't get it. Things about child abuse, you can't get it anywhere. Nobody can get it. There's a federal law. Any of you guys cover education? It's called the, FERPA. Has anybody ever thrown FERPA out at you? It's a Family Educational Right to Privacy Act. It says that school boards, educational institutions cannot release records that would personally identify kids. So that would override the FOI Act. So you need to know, just make sure that, let me rephrase that, so that if they throw one of those out at you, you have to know whether or not it exists. And if you don't know it exists, check it before you accept the answer. There are 27 exemptions in the FOI Act. They're in section 1-210, and they are a little different in that they are what are called permissive exemptions. So where those exceptions that I just talked about and the exclusions, the primary one is the home addresses of certain working people, judges, correction officers, things like that. You might get a document and see an address redacted. It's because one of those people in those working groups is in there. But the exemptions are permissive. What that means is that an agency is permitted to withhold those records, but not required to. So the idea would be they look at the record, they say, oh, we think it meets an exemption, but we're going to give it out anyway, or it says it meets the exemption, we're going to withhold it. So they've got to make sort of two calls on whether the exemption fits or whether it doesn't. The exemption that you probably deal with a lot is one for personnel files. You ever ask for things in personnel files? The law says that they can withhold something in a personnel file if they believe that releasing it, would be an invasion of the person's privacy. And the standard for invasion of privacy says that it must be both highly offensive and not a matter of public concern. It's got to meet both prongs. So they look at it and they say it would be highly offensive to release it and not a matter of public concern.
So if, and please forgive me for throwing out this hypothetical, but so if a cop sodomized somebody while he was in uniform, that they could still deny?
No, excellent question, excellent way to phrase it. It's clearly highly offensive, right?
Right.
But it is a matter of public concern. If the cop in uniform performs it, it's got to meet both prongs of the test.
Okay.
It's a great example. Right here in Middletown, one of the examples that I used a couple of years ago, there was a situation where there were rumors about an officer having trouble at home, big trouble at home. They put him on desk duty. They did a complete investigation, completed an internal affairs report. The report said, yes, he's having a lot of difficulty at home, but there are no issues in his performance of duty. He's doing a great job. The current wanted to see the report when they were done, and the PD said, no, highly offensive to tell everybody, to tell the world what he's doing, and not a matter of public concern, because it had nothing to do with how he was doing his job. So, trouble at home, they investigated and found it, and he's working on problems at home, but it has no impact on his performance. So they said invasion of privacy, they're not going to give it out.
But, well, excuse me for being nitpicky here,
Yeah.
but that's one entity's opinion that it's not affecting his performance. I mean, when you go to court in a civil matter, you get multiple experts that get called in, and one will say one thing and one will say another.
That's what the report said.
Okay.
And that's what the current was asking for. And the current filed a complaint, and we agreed with the police department. Highly offensive to tell the world what's going on in his home, nobody needed to know it, and not a matter of public concern because it had nothing to do with how he was doing his job. Complaint dismissed, report was never released. In Enfield, there was a situation with an officer who was doing things at home, again, not so nice. Different from the activities in the Middletown home, to the point where he was recording some of these activities, again, use your imagination, and he put them on a thumb drive, and the thumb drive made its way into the dash cam of his police cruiser. His partner saw it, told the chief, the guy's asked to resign. He leaves, Manchester JA wants to see the report, what happened to the guy, because otherwise he had a pretty good reputation, where did he go? Manchester says, no. Manchester says, Enfield PD says no, this is really disgusting stuff, it's highly offensive, we're not going to give it out. So Manchester files a complaint with the FOI Commission. The FOI Commission initially says, this is really gross, this is really nasty stuff, we're not going to give it out. And then thought about it and said, wait a minute, if this guy goes to Middletown and applies for a job, or Atlanta, Georgia and applies for a job, don't they have a right to know why he left the Enfield PD? Don't they have a right to know at least what? So what we ordered was a partial release of that report, so that just enough came out, because we felt that it was highly offensive, for sure, but it clearly was a matter of public concern. It didn't meet both prongs, and the courts upheld that.
But don't governing bodies do that all the time, where they're so afraid of being litigated against that they'll either allow somebody to resign rather than have them fired, or I can think of a couple boards of education have given recommendations to people who again go down and presumably violate.
Can't really speak to that. All I know is what happened in this case, and that they felt it was important that the world knew at least partially what this guy had done. So,
Okay.
it was in the report. It was in the report, and
Was
the
it
question
criminal? Was it criminal?
it bordered on it. He wasn't charged. In fact, he got a job with another police department in Vermont or Maine or something like that.
But in the case that I'm thinking of, in one of the towns that I covered, the former principal of Cheshire High School had previously held a job in Milford.
Sorry,
Sorry.
you're not supposed to call me. All right, well. See, when you have children who need money, the phone goes up. I didn't see a clock in here, so I put this up for the clock.
Yeah, it's about 3:15.
Okay.
He previously held a job in Milford as assistant superintendent. He'd worked there for approximately 4 months, 3 of which he'd spent on unpaid leave. The rumor was that he was falling down drunk. He lasted in Cheshire for about a year and a half, and then he left.
Right.
And I mean, yes, having alcoholism is a personal issue, but if you're coming to work drunk,
The public has a right to know.
the public has a right to know.
Right. And I would argue that if that's in the report, that should be released. And we would too.
I mean, I don't know that there was ever a report out.
Well, that's what they were cagey about it. Enfield PD did a report, so.
So you're better off, in that case, you're better off going for a fishing expedition if you believe that there's even a chance that there were reports out
Any and
there.
all documents pertaining to the dismissal. And then what you will get, 9 times out of 10, is we signed a confidentiality agreement. Remember that separation agreements are not confidential. They cannot be withheld. So, does anybody have any other questions about any other records? Anything, possible exemptions, things that you've had trouble with? No. Police records. Remember that, if somebody's arrested, there is no such thing as a, arrest that's secret. The bare minimum has to come out. Who was arrested, when they were arrested, what they were arrested for. That has to come out. And if anybody tells you that someone was arrested but they can't tell you anything, that's not right. The law says no secret arrest.
What about juveniles who get arrested?
You're right. They can tell you that a juvenile was arrested by the arrest records of juveniles by statute. That overrides, that's one of those except as otherwise provided.
So is
juveniles
there
don't get-
anything they have to, or can they withhold the entire arrest and pretend that it didn't happen?
My suggestion to them is always to redact the names and say that a juvenile was arrested for X, Y, and Z, especially if it's a major case.
Another arrest question. If a local police department receives a warrant or something from an agency out of state, does that become a public document
Yes,
that the
it
local
does.
agency has to give out?
Yes, it does, yes. In their hands, once it crosses the threshold, it's a public record. Okay, take a couple of these, I'll give you the whole stack. You can pass them on to all your friends and family. This is the Freedom of Information, I call it the Freedom of Information American Express card. Don't leave home without it. It's great for a wallet, a desk drawer, a purse, highlights of the act, so to maybe help you on the fly. And in addition to that, our name, our address, our phone number, our website can be helpful. You have a question about an issue, you type it in, I wonder if they've ever dealt with this before, and the cases that might come up. Don't ever hesitate to call and ask a question or send in an email. Ask for me, I'll give you an answer. It may not ever be the answer you want, but it'll be something on which to base, you know, your next step, the next thing you're gonna do. So I'll leave these for you, and you can distribute them. Anything